Good afternoon, everyone. Welcome, Your Honours and eminent guests, and welcome to members of the Criminal Bar. It's delightful to have you all here this afternoon. And a particularly warm welcome to the Honourable Rob Hulls, the Attorney-General for the State of Victoria and also Deputy Premier. Well, I probably need to say very little as we sit and gaze at this breathtaking room. What has been done through the support from the Victorian Government is just extraordinary. The renovation and restoration of this very, very beautiful but historic courtroom. This afternoon, the Attorney-General will kindly launch and reopen the courtroom, to be followed by some remarks which I will introduce in a moment by His Honour Justice Vincent. I now invite Mr Hulls to reopen Court 4.
Thanks very much, Marilyn. Can I welcome everybody here this afternoon, and it really is a very important occasion. As we know, for 124 years the Supreme Court of Victoria has certainly been the linchpin of Melbourne's legal precinct, and for many Victorians, I guess it serves as a physical embodiment of the justice system. The Supreme Court's rich legal history and architectural heritage have made it an icon, but it's not a relic from the past to be admired from a distance. It is, as we know, a thriving court which hears complex, high-profile and lengthy trials and accommodates thousands of court users each year. The refurbishment of this Court 4 has restored one of the Supreme Court's busiest criminal courts, and indeed further increased its capacity. Last year, up until the works began in October, 52 cases lasting up to 30 days and ranging from bail applications to murder trials were heard here in Court 4. The court, as you can see, now has up-to-date technical facilities and improved security, jury facilities, custody docks and public seating. Court 4's upgrade is part of the $22 million redevelopment of the Supreme Court included in the Melbourne Legal Precinct Master Plan. The extensive work have ensured that whilst the courts have retained their grand beauty, they are also modern and, just as importantly, user-friendly. The aim of the Master Plan is to consolidate and enhance the role of the legal precinct, to optimise the delivery of court services, to improve court administration and to provide a long-term sustainable plan for this very important precinct. This project is part of the state government's investment in not only the physical infrastructure of the courts, but in the justice system as a whole, to make it quicker, to make it fairer, and of course more responsive to the needs of all Victorians. And to this end, I might say, as many of you would know, Crown Counsel John Lynch is currently reviewing a proposal to establish a single criminal list, and I certainly look forward to his report. A single criminal list could well enhance court efficiency by reducing delays in criminal trials and making the best possible use of our judicial resources. I'm sure you'll all agree we need to ensure the higher courts are not congested by matters that can be dealt with more appropriately in other jurisdictions, and we have to ensure that we most appropriately match cases with judicial skills. We want to ensure that there is a seamless relationship between the different courts and their diverse functions. The community expects and indeed deserves a unified and accessible justice system. The refurbishment of this magnificent court is part of a statewide courts construction program which is worth almost $200 million. So I'm certainly thrilled to be here this afternoon, very proud to be here to, I don't know if there's a red ribbon, but to officially open this modern and magnificent court facility, and I certainly wish every success to all its users. Thanks very much for being here.
Thank you, Attorney. Of course, when we reflect upon the history of this courtroom, there is one individual who has spent an extraordinary amount of time down here at the bar table and then later in his career up here on the bench, Justice Frank Vincent. It seemed quite appropriate to invite His Honour this afternoon to provide us with some brief reflections upon his experiences in Court Number 4. Your Honour.
It seemed only appropriate, if you're looking at an historical monument, to have at least an elderly figure in contributing. But thank you, Chief Justice, for the opportunity to contribute to this occasion. For a number of reasons, this court holds special significance for me, and it's wonderful to see it so splendidly restored and adapted for use in the new century. I only wish that I could undergo a similar process. My connection with this room began over half a century ago, when as a second or third year law student, I sat in the public gallery and watched the charismatic Frank Vincent, who was then at the height of his powers, successfully defend a policeman charged with the murder of his wife. Obviously attributing his success in some small part to divine intervention, immediately after the verdict, Frank and his client walked down the street to St Francis Church to pray. Their piety was observed by a passing newspaper reporter who by chance was in the vicinity and who happened to have his camera ready at the time. Galbally, who could never be accused of understating his position, in a later broadly similar case in this court, reminded the jury that 2,000 years ago, a man died for love on a cross on Calvary. The prosecutor, my much admired and long-term friend and opponent Jim Morrissey, responded that there were a few differences between their situations, including the fact that the earlier person had not shot his wife. It was in June 1964, at the age of 26 and as a barrister of 3 years standing, that I first took my place at the bar table here, appearing on behalf of one of two men charged with murder. The trial judge was Justice Monaghan. He was a great criminal lawyer and a great judge. I'm reasonably confident that he was even more terrified by my lack of experience than I was. A wily prosecutor named Bill Fazio, leading a young Michael Kelly, represented the Crown, and the legendary Jack Lazarus appeared for the co-accused. I remember telling my client, who I recall was known, and I should add not inappropriately, by the name of Lardhead, that I had not appeared in a trial of that kind before. He responded that that was all right, as he was similarly inexperienced. Somehow or other, we both managed to negotiate the process successfully. However, I often wondered whether even Lardhead's equanimity was shaken at the commencement of the hearing. In an endeavour to present myself as totally at ease, a kind of cross between Bobby Darin and the Fonz, I decided that it was necessary for me to appear cool when I announced my appearance. I actually practiced this. I shrugged my gown casually round my shoulders. I appear the accused. And various other utterances which went over very well in front of the mirror. It all went terribly well until I realised, and it was pointed out to me, that I had actually announced my appearance for the wrong person. Counsel appearing in those trials were forbidden to refer to the death penalty. Of course, particularly in cases in which there was some chance that it might be imposed, it was almost impossible not to make some comment obliquely referring to it. When this was done, the judges generally would let the breach pass without anything being said. In that trial, however, my reference could hardly be described as a passing allusion. I concluded my final address with the statement, in one sense, it can be said not to matter whether this trial ends with the clang of a jail gate or the snap of a gallows rope, for each is a terrible sound. And I just pray to God that it's not in the moment of silence that follows that sound that you discover the meaning of reasonable doubt. It's the first time I ever saw a judge who had definite murderous expression on his face. All that I need to say of his response is that it's remained strong in my memory. Waiting for juries in those cases was very stressful. In that matter, the jury returned quite late on a Friday night. The prosecution and the defence team, which included a young law clerk named Ian McIver, had been waiting in a nearby watering hole, and it is enough to state that it was good for all concerned that the jury wasn't out any longer. When they did return with a verdict of guilty of manslaughter, Jack Lazarus stated quite helpfully, I thought, and I believed in reference to his client's position rather than any of ours, "It's the drink, Your Honour." The judge responded, "Quite so, we'll adjourn till Monday." As both a member of council and as a judge, I spent a very large part of my working life in this room. As a barrister, I appeared in Court 4 for over 20 years. Once I appeared in 4 murder trials in immediate succession in this courtroom. Throughout that period, there were only 2 possible sentences in those cases. The death penalty, which was abolished at the end of 1974, and imprisonment for life. For practical purposes, therefore, all cases were contested. It was indeed unclear whether a plea of guilty could be lawfully entered in a death penalty case, although I am aware of one occasion on which it was accepted. On 4 occasions I sat at the bar table here, devastated, as I heard my client sentenced to death. On one of them, the judge, who was a sensitive individual, after imposing sentence on the co-accused, realised that he had not asked whether that man had anything to say. Accordingly, as I said, being a sensitive individual and concerned with the proprieties, His Honour had the individual brought back before the court, apologised profusely to him, then asked him if he had anything to say. The unfortunate man, who was totally shell-shocked by the fact he'd just been sentenced to death, muttered no. His Honour then sentenced him to death again, and again apologised for his omission. As a trial judge for 17 years, I presided in a very large number of cases here. The Russell Street bombing trial, the trial of the persons accused of the murder of the police members in Walsh Street, the 8 police members charged in relation to the death of Graham Jensen, the trial arising out of the death of Gary Abdullah, the first murder trial of Peter Dupas, the plea hearing of Beckett and the trial of Camilleri for the killing of the Bega schoolgirls, the plea in relation to the serial killer Paul Denyer, and a vast number of less well-known proceedings. The first hearing in what was then called the Central Criminal Court commenced on the 14th of February 1884. It was, the Argus of the following day reported, the real opening of the newly constructed building and the newspaper recorded that the court was thronged with people. In a kind of journalism that you would not encounter today, the article continued, "At 10 minutes past 10 o'clock, amidst a silence which the voice of the crier was not needed to produce, His Honour entered the bench from a little door at the back. The bar rose and a compact row of wigged heads bowed deferentially, the judge responding in like manner to the salute. A moment's pause occurred, while expectation was on tiptoe to hear the first official words which should yet agitate the yet unsanctified air of the court. His Honour made no sign, and the bar had no nerve to speak. The associate was the only man equal to the occasion, and his first memorable words were, "Bring William George Clamp to the bar." An officer in the dock dived down into the bowels of the earth by way of the stone staircase, and presently brought up from the underground dungeon a prisoner. But his name was not William George Clamp, and he was ignominiously dismissed to the regions below, amidst the unchecked titter of the spectators. The real William George forthwith appeared, and the business proceeded as smoothly as if the first event in the court had not been a bungle. The Age journalist who reported on this courtroom a few days later in an article entitled "New Law Courts Blunders" was singularly unimpressed by this room. He stated, "The great bête noire of the new structure appears to be the Central Criminal Court, which in the first place is difficult to find and which when found is seen to be defective in the last degree." He was critical of what he described as the utter absence of acoustic properties and continued, "Another difficulty is presented by the peculiar principle on which the different persons are located, the jury being to the left of the bar, the witness to the right, and the prisoner immediately behind. A zealous counsel, therefore, who desired to keep all parties before him would be required to be perpetually revolving so as to face all corners, an operation which could only be gracefully performed on a piano stool or some similar piece of mechanism." It's interesting to see the bar table has been moved back 124 years later in response to that criticism, Mr. Attorney. He pointed out that it would not be a pleasant experience to be tried in this court, saying, "In a British court, where every man is supposed to be innocent until he's proved guilty, it seems incongruous that a prisoner whose guilt has not yet been established should be compelled to traverse an underground tunnel which leads to an underground cell where he is exposed to the utmost discomfort till his time for trial arrives. And when that eventual epoch has come, he is sent up a flight of stairs into the prisoner's dock, the place which for barbaric and repulsive appearance could hold its own with some of the halls of the Inquisition." It's been changed. In this dock, designed in such a humane and genial style, no seat is provided for the prisoner, who, it must always be remembered, has not yet been proved guilty, and it is enclosed with an iron railing, surmounted by cruel, barbarous spikes, an ingenious invention intended to prevent the unconvicted prisoner from even leaning on the railing, no matter how many dreary hours the case may last. Well, we've softened a bit since then. There was also considerable criticism of the straight-back throne-like chairs with which the court has been provided and which still litter the halls of this place. They were being used when I first came here, and one of them I noticed was in the Banco Court and employed for Justice Coldry's farewell last Thursday. For the major part of its history, Court 4 has been used for the most serious criminal trials conducted in the Supreme Court. It was also used from time to time for hearings by the Old Court of Criminal Appeal, generally referred to as the Criminal Court. Within its walls, our community and our legal system has confronted and been confronted with an extraordinary range of human problems and interactions for over 124 years. It was here, for example, that Colin Ross was tried and convicted in 1922 in relation to what became known as the Gun Alley murder of a little girl. Ross was later executed. As Justice Weinberg pointed out in a paper concerned with the problems of delay in the criminal process, Ross was charged on the 12th of January 1922, committed for trial on the 26th of January. His trial commenced on the 20th of February. The verdict was on the 25th of February. His appeal to the full court was denied on the 20th of March. His application for leave to appeal to the High Court was refused a fortnight later, and he was hanged on the 24th of April. The process appears to have been highly efficient, as it was completed in just a little over 3 months. But I observed in quite recent newspaper reports that you, Mr. Attorney, have sought the advice of 3 members of the court concerning the possibility that they may have been just a tad too quick. Within my personal memory, William John O'Mealy was convicted of murder in this room. Later, a man named Taylor and he were the last persons in Victoria ordered to be whipped. Twice in this building, but not in this room, I was required to present submissions for men who were at risk of the imposition of that barbaric punishment. In this room were conducted the trials of Lee, Clayton and Andrews and Ronald Ryan. Jean Lee was the last woman and Ronald Ryan the last man to be hanged in this state. Great judges and advocates, and some who are not so great, have occupied the bench and bar of this courtroom over the last 124 years. It is said that there's a ghost in Court 4. If there is, I'm sure it knows me well, and perhaps the time will come when we'll get together and compare notes. Thank you.
Thank you so much, Justice Vincent, and what a celebration of the criminal law your remarks represent. Finally, before closing this evening, there are acknowledgements that must be made when such an achievement occurs. Thomas Knoll and the major project staff from the Department of Justice, Bob Sinclair and staff of Billard Lease, the architects, Les Gordon, Keith Kilmartin and the staff of L.U. Simon. And I must say, from the judge's perspective, this work has been achieved almost seamlessly with very little interruption and imposition on our daily work. Peter Chapman, Des Campbell from the staff of the Supreme Court have been extraordinary in their efforts. And I particularly thank His Honour Justice Osborne, who cannot be here today. He is in Europe looking at courts over there, but His Honour has been extremely instrumental in this outcome. We also acknowledge the contractors, IPP Consulting, Rutledge Engineering, Systems Cabling, Higgins Painters, and what a masterpiece this is, Lincoln Scott Consulting Engineers, AC Goulding Plumbers, and most importantly, Attorney General and Deputy Premier. The judges and I thank the State of Victoria for its vision and generosity in enabling this wonderful facility to be achieved. I now close the proceedings and invite you all, each and every one of you, to a very warm and welcome afternoon tea just a little down the corridor near the Banco Court. So please do come. Thank you.